Hello and welcome to the Sidebar, presented by True Crime Daily, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We're recording this on Friday, April 12th, 2024. In this week's episode, the murder trial of an alleged Doomsday prophet begins as his defense attorneys seek to place blame on his devoted follower and wife in an effort to avoid the death penalty. Also, a fatal border confrontation in the case of a rancher charged with murdering a migrant who wandered across his property. But first, the sentencing of the Oxford school shooter's parents and the possible implications for parents nationwide. Today, we are joined by Bob Motta, a criminal defense attorney, legal analyst, and host of the true crime podcast, Defense Diaries. Bob, welcome back.
Thanks, Joshua. Glad to be here. Excited to see you, man. It's been a minute.
I know, it's been a while, and I always look forward to having you on the show because you do your podcast, which is so in-depth and has so much lawyer-specific analysis, which I appreciate. But because of that, too, you're in the weeds on a lot of these cases, and I really appreciate talking to someone who follows them so closely and knows these little details that you can share with all of our listeners and viewers. So with that all being said, no pressure, but let's jump right in. First, out of Detroit, Michigan, both parents of the Oxford school shooter have been sentenced following a landmark prosecution that may set a legal precedent for the criminal culpability of parents. Jennifer and James Crumbley both received sentences of 10 to 15 years behind bars following their separate convictions on 4 counts of involuntary manslaughter. The charges represent the lives of students Justin Schilling, Madison Baldwin, Tate Meyer, and Hannah St. Julian, who all had their lives taken by the Crumbley son, Ethan Crumbley, in the Oxford High School shooting. At sentencing, parents of the shooting victims gave their impact statements confronting the Crumbleys for their gross negligence and failure to intervene in the fatal actions of their son. One mother told news outlets that the sentences were, quote, send a message to parents throughout the country. The ripple effects of the message are yet to be determined, but it is clear that parents will be opened to their increased liability and prosecution for their actions of their children. Bob, jump right in. I mean, first of all, I'm curious to hear your thoughts on the verdict, and then I'm curious to hear your thoughts on the sentences that were just handed down, 10 to 15 years per for each of the parents. What are your thoughts?
I was of the firm belief that they were guilty. I watched that trial. I streamed that trial. Both of them, both Jennifer and James trials, and I was stunned at the lack of involvement with these two parents with respect to that boy. And, I also realized that the political side of it, because it was such a fascinating case because of you have Second Amendment issues involved. You have politics involved with it. You have, as you said, it's a watershed case with respect to this is the first time that any parents in this country have ever been held under a homicide statute to be potentially responsible for the actions of their child outside of their presence. And I understood going into Jennifer's trial, which went first, just how big of a verdict that this would be if it came back guilty. It would put every parent in this country on notice that you need to wake up, quit looking at your devices all the time, be more involved in your children's lives, try to figure out what's going on with your kids. If they're showing any signs of distress, don't ignore it, because you know what? If you decide to do those things, if you decide not to do those things, ultimately what can end up happening is that you can be held responsible for horrific acts that they may commit outside of your presence. And that's a terrifying prospect. But when you look at what the option is, which is just decent parenting, I had no problem with it. And frankly, I was in support of the verdict. I think the jury was incredibly brave to come back with that verdict, because I think that they had an understanding of exactly what the ramifications of that verdict would and could be. And I think without question, law enforcement agencies and prosecutor offices around the country are going to be looking at these school shooter cases in a much different way. Now, where they're going to be looking, they're saying, you know what, we need search warrants for the parents' phones. We want to know what was going on in the relationships with these kids. Were the kids giving them the warning signs that would give them the foreseeability that this was a possibility? And if so, and they ignored it, you know what? They're on the hook. Because like the prosecutor's office was incredibly brave to move on this. I mean, you're a former prosecutor, Joshua. I mean, this you're not in the business of not winning cases. I mean, your job is to secure convictions on cases, and if you don't feel that a case is strong enough, you're not going to move on it. And this case could have gone either way, not so much because of the factual scenario, but more because of the political overtones and the potential chilling effect that it'll have all across the country with respect to parents. And and you saw it online. You saw this divide, where you'd see the people like, oh, so now I'm going to be held responsible for everything my kid does. If my kid steals a piece of gum at a store, now I'm going down for that. No, that's not what this is. This is an issue of foreseeability. When there's something that absolutely tragic like this happens, if you had telltale signs and you chose to ignore it, that's your responsibility. It is not the duty of the school to raise your children. It is not the duty of anyone other than the parent to raise their kid. And to me, the most powerful piece of evidence, I didn't care so much about everything that had occurred prior to the day of the shooting, when both parents were called into that school and they were handed that math test and they looked at it and it said, can't stop the thoughts. It had in all bold letters, help me. It had blood everywhere. My life is meaningless. The world means it. It was like any parent that is handed a document like that the morning of what ultimately becomes the morning of the shooting and elects to keep their kid at school, to me, had all the foreseeability that you could ever require to know that there is something desperately wrong with your child, and you need to address it immediately. You don't leave them at the school, and is the school absolved of any blame in this? No. I mean, my school district, if there's any inkling of anything going on like that, they shut the school down. That's what happens. So does the school have responsibility as well? Yes, but the ultimate responsibility to me lies with the parents.
Yeah. It's hard to or it's hard to think of a case in recent history that has had more people looking outside of it from its results to how it's going to affect society at large. There are many cases that people follow very closely and that get a lot of news attention, but that has to do with murders or horrible financial crimes that people don't look at it and go, wow, I could find myself easily in that position. But in this case, you have hundreds of thousands of parents across the country going, wait a minute, what now is going on? I have a kid. Many parents, by the way, with very troubled children, maybe not to the degree that we saw in this case, but many parents dealing with kids who are suffering from all sorts of, either diagnosed or untreated mental issues and emotional issues, and they're all just doing their best, I think, and struggling to try to deal with it. And I was, I understand exactly what you're saying about you felt this was the right verdict. I was troubled by this case for a lot of reasons, and I agree with you. The conduct of the parents here was egregious, but so much of the criminal law has to do with drawing lines that people can learn from setting a precedent to say this is behavior that will not be accepted. And in this case, and my question to you, I guess, is where now have we drawn that line? I understand that this was egregious, but what where's the line? At what You're right. Parents are going, well, stealing a stick of gum. No, that's not the line. But what is the line? Is it my kid writes a bunch of troubling stuff and I need to pull him from school and put him in therapy immediately? Or where do you think, what do you think is the takeaway for parents after this?
I mean, Joshua, you're right. It's a murky line. It
Yeah.
certainly is no bright line rule. And, ultimately, I think it's going to be a case by case basis. To me, if this verdict results in one less school shooting, it's a massive victory for all of us as citizens of this country, for all of us as parents that I send my kids to school every day. You and I did not have to live this life. We did not have to do active shooter drills in school. Like where I lived in the Midwest, we did tornado drills. That wasn't even a thought in our minds. And to think that my child has to live in fear of knowing that there's a possibility that, they could be in school and their lives can be lost, which they have to know because they're going through the drills. It's not like this is some kind of like secret that we're trying to shield the children from. It's just, it's unfortunate that that is what our society has become. But the fact of the matter is that is what it is. So in terms of what that line is, I think the easiest answer is there is no line, but it's going to be dealt with on a case by case basis. It's going to be looked at case by case where they're going to say, look, I'm going to look at everything that was going on with this family prior to leading up to the shooting. And I am going to determine, I being law enforcement and or the prosecutor's office, determine whether or not this was foreseeable. Because if they elected to do nothing and there were telltale signs, then you're culpable. Like that has been shown that you can be held culpable. Foreseeability was the issue in this case, and this was foreseeable. It just was. Everyone in that office that morning had the opportunity to stop this from happening. James Crumbly saying that I have to I've got to work, and Jennifer saying I have to work. Well, he's driving for DoorDash. Stick your kid in the car with you to do your deliveries of your food. And then me personally, I wouldn't have had to hear one word what the teachers were saying or the counselor was saying to me. As soon as that was put in my hands, I would have immediately grabbed my child and said, you know what, we're going to go. I'm going to go get you evaluated. And in the entire trip to the whatever hospital is near us, I'm trying to break through with my kid and trying to understand what's going on with them. And in a case where, like suggesting what you were talking about, if parents are doing the things that you would expect a competent parent to do that's fulfilling their duty as a parent, they're not on the hook in my book. You can't control every movement that your child's going to make, especially outside of your presence. If you've got a kid that is having problems and you're sending them to a psychiatrist or a psychologist or trying to get them some kind of treatment, and you're making active moves to try to better their life and try to improve their mental health, well, then you're not culpable in my book. I mean, you can't control. This isn't about that. This is about having knowledge of something that's going on and either ignoring it completely or not, and like that's where it gets fuzzy for me. Like, where is that? Like, how much is enough is going to be what the question is, So I mean, we're going to see how it's going to play out. But like I said, I mean, something had to be done. I don't know if you have school age kids, man, but I have to tell you, it worries me constantly. It's not a constant thought in my mind, but every time this happens, which is way too often, it's the first thing that pops into my head. Like it's the absolute first thing. And I've gotten more than, more emails from the school alerting us that they've shut it down. And they put the kids in active shooter mode for me to be comfortable, even though nothing had transpired. I mean, they're overly cautious, which I'm fine with. So to me, something had to be done. Nothing's getting done from the legislative side of it with respect to gun control. So I was happy to see something happen that I think will have a positive effect on hopefully chilling some of these school shootings.
No, I listen. I completely echo your frustration and despair at what we see happening again and again and again in this country. And I completely understand the efforts that everyone is trying to make to try to do something about this problem. And my heart breaks for these parents that had to get that phone call. I mean, I cannot imagine the nightmare that they
Ugh.
have lived through and continue to live through. And so I understand that exactly what you're saying about we all want to do something. It's just the that lawyer part in me starts to get a little nervous at at where are we going to start drawing lines. And you're right. Are we going to see in these cases now where there is violence, God forbid, on school campuses, are law enforcement immediately going to say, I want search warrants on the parents' phones? And you're right. Are we now saying that they're entitled to that? Is that going too far? Is that are we extending the bounds of reasonable search and seizure? I don't know. I know that one takeaway I think that was clear from this case was these parents were dealing with a crisis with their son, and there were a lot of red flags and a lot of things they ignored and a lot of bad parenting. But what I think really distinguishes this case was introducing the weapon. I agree with you. I think we're going to see other cases to follow as prosecutors' offices become a little more emboldened after the results in this case. But thank you for sharing your thoughts on that. It is tragic, and we'll see how this develops in coming cases, I guess. Let's move now to Tucson, Arizona. As border debates simmer nationally, a case in Arizona pits the rights of migrants against the rights of a property owner. George Allen Kelly faces a charge of second-degree murder for the death of Gabriel Quinn Butamea after Kelly allegedly opened fire on Butamea and other unarmed men walking across Kelly's 170-acre cattle ranch. Prosecutors claimed that Kelly shot the man with an AK-47 before waiting over 3 hours to call emergency services. Kelly claims that he fired only a warning shot at what he feared were armed drug traffickers. Interestingly, no gunshot residue was discovered on the victim and no bullet was ever recovered. The fact has been spun by both sides in the trial, with prosecutors alleging it proves that Kelly fired at the victim from a great distance, making the rancher in no danger at the time of the shooting. Kelly's defense, meanwhile, contends that lack of any forensic evidence suggests that an alternate killer may have been involved, which was never investigated by law enforcement. Prior to the trial, Kelly rejected a plea that would have reduced the charge to negligent homicide. The trial is expected to last another couple of weeks, with jurors making a field trip to Kelly's ranch. Bob, I want you to try for me to wear a couple of hats for a moment and tell us what you think are the strongest points for the prosecution in this case, but what are also the strongest points for the defense?
I think probably the strongest case for the prosecution is the fact that there was no gunshot residue found on the victim, nor was the projectile found, which would indicate that he was sitting there picking him off from a long distance. Which, when you're talking about trespass to property, of 170-acre, area of land, like, you just can't, while you absolutely have a right to have those people leave your property, you can't just start killing people that happen to wander upon your land. I mean, that's a bridge too far in terms of what we can allow for in this country. And I mean, a man's home is his castle. We know that. That this isn't as if it was a home invasion. If this was a home invasion and they had broken into his ranch proper, it's a different case that we're talking about. Here we're talking about that this guy's wandering somewhere on this massive piece of property. He sees it and allegedly fires on the guy, killing him from what appears to be a great distance. Now, to me, that's very powerful evidence. To me, it's not justified. I mean, the show of force has to be in some way attributable to what he feels is the threat level. And obviously, from that distance, there's no threat whatsoever of at least great bodily injury or death. I mean, which is always what you're looking at when you're talking about like a kind of a self-defense type of claim. Clearly, in this scenario, I think that the defense is going to be hard pressed to establish that this person had a reasonable fear in terms of allowing him to get to the point where he felt it was necessary to fire his weapon and ultimately kill the person, if that's in fact what happened. From the defense side of it, I think that I'm leaning heavily into the fact that my guy didn't fire the gun, that you have no evidence whatsoever that it was my client that actually fired the bullet. It's a huge piece of property. It could have been anybody that was on my land. Like, I have no idea what was going on out there. I mean, maybe it was a drug deal gone bad. Maybe they were in the middle of my property, trying to conduct some drug transaction, and this thing went sideways and this guy ends up dead. So, I mean, that's what I'm leaning into. I'm certainly not going to try to be relying on self-defense, because I think that will fail for the reasons that I said, that the state's case was strong with respect to, their case against him in terms of reasonableness, and I just don't think that if he's coming at them with a self-defense type of claim, that any juror would find that to be a reasonable response. I mean, we saw it. I don't know if you're following the Nikolai Mew case, which just came to verdict yesterday. That's the Apple River stabbing case, where the guy's in the river, which is public property, so it's a little different scenario in that there's no claim to privacy or claim, land claim there, but you've got, everybody has a right to be where they're at. And this thing just devolves into a situation where you've got one individual with ultimately being surrounded by 13 individuals, or somewhere between 11 and 13 individuals, who all think him to be, some kind of pedophile, because one of the kids starts calling him a raper, and he's looking for little girls. So everybody has the wrong impression about this guy, and everybody's intoxicated. And the guy ends up stabbing, killing one of the kids. Ultimately, he came with a self-defense type claim, which I think when you watch that video, that was another case where you have a very divided opinions on that, whether he was in his right to defend himself. And I was torn, like, I would flip-flop as I watched that trial. I'm like, man, if I'm in that position, surrounded by that many people who are, really acting like it was kind of a Lord of the Flies type situation, screaming and pointing, and ultimately he gets punched and he's pushed to the ground. I mean, I don't know what I'm going to do in that situation. It's hard to know individually what you'll do. That's why these kind of cases are always fascinating, because it really boils down to our own personal experiences, our own life experiences, in terms of what we may determine to be reasonable in a certain situation. We don't really have that here. You know what I mean? So I think that what the defense is going to have to rely on, it was like a Saudi thing, like some other dude did it. It wasn't my guy. You don't have the proof that it was my guy. Good luck proving it.
Yeah, no, I agree with you. The strongest point, I think, for the defense is that there's no forensic evidence, that they never recovered the bullet. They cannot put together a trajectory analysis. They don't have ballistics. They don't have gunshot residue. They got nothing that they can tie this to their client, other than, unfortunately, their client's old words saying that he fired a weapon and saying that he fired in that direction. And that brings me to my other point, that for the prosecution, I think their best point is what you point out, but also the distance. Even according to his own admission, it's 100 yards away. This is not people were running up on my home. This is people 100 yards away. And by the way, my understanding of warning shots is that the point of them is the noise they make, right? So you can shoot those directly in the air to get the effect you're looking for. I don't see what the point of having a warning shot that is a shot across the bow over people's heads as they're walking along. That is to me the biggest problem, is that, sir, this was at best for the defense reckless in his the way he was behaving by firing at them or close to them. And again, though, that comes back to the defendant's own words. He's the one who said where he fired. So it's interesting that I think the strongest evidence for the prosecution might be coming out of the defendant's own mouth. This actually yesterday, as we're making this recording, the jury went out and took a look at the ranch, which is, as you know, pretty rare for trials to have happen, for judges to actually get everybody together, the security involved, bring them out to another location. But somehow the prosecution felt that that was important here. Who do you think stands to benefit more, the prosecution or the defense, by the jury going out there?
That's a tough call, because the size of the property like kind of cuts both ways. You know what I mean?
Yeah.
I think it helps, like, in light of the fact that the defendant did make a statement that he did discharge the weapon, albeit he's claiming that it was done in, just a warning shot type fashion, which, as you aptly noted, typically warning shots are straight up in the air. You're not
Right.
firing them at a trajectory where you're going to potentially hit somebody. I don't know his background. Is this guy like a marksman? Like, do we know? Is he a crack shot? Like, you know
Right.
what I'm saying? Like, I'm assuming that those types of facts will come out, but I would think, for the purposes of the prosecution's mindset, that they believe that it'll be helpful, because of the fact that they're going to try to sear into the minds of the jurors. Look, this guy was a football field away. All right.
Yeah.
There was no threat of physical harm for this guy. And I want you to stand right where we found the victim, and you look back for where he claims he was standing, and you tell me, Madam Juror, Mr. Juror, do you feel that that's reasonable to feel that you would have a risk of great bodily injury or death from that distance? I mean, like you said, it is rare for those field trips to take place. We saw it in Murdoch, and we know how that went for the defense. Not that
Yeah.
that was the thing that sunk that ship, but it certainly didn't help them. So yeah, I think ultimately, in terms of what the prosecution's hoping will happen, is that it really kind of gives you that spatial recognition of just the amount of distance between where they're claiming the shot was fired and where the victim was shot and killed. So, like,
Yeah.
I think it could be helpful, because
I,
it's like, talking about it's one thing, and trying to say, okay, well, imagine, if you're in a football stadium, somebody's standing in one end zone and somebody's standing in the other. That was the distance. It's different to talk about it than to see it and stand there
100%.
and visualize it yourself. So
100%. People, I think that's one of the biggest problems is people have a hard time estimating distance, spatially estimating things in their head. If you ask those 12 jurors to point to an object 100 yards away, you probably get 12 different answers, and they would be widely different in their assessment of what that length is. But when you actually bring them out there and have them stand on his porch and then point to a flag where the body was actually located at, if that's a
right,
football field away, they're going to be squinting their eyes and saying,
right.
wait a minute, you're telling me that way over there is what you were afraid of, and you felt like you had to fire at that rather than up in the air? That, to me, I agree with you. I think it's going to be powerful stuff for the prosecution, but we shall see. That case is supposed to continue for another couple of weeks. We will, of course, keep everyone updated and follow that as it develops. Let's move to our final case out of Boise, Idaho, where an alleged religious prophet who left a trail of bloodshed in his wake is facing trial months after his wife and devoted follower were convicted on similar charges. Chad Daybell faces charges of first-degree murder, insurance fraud, conspiracy to commit murder, and grand theft in the alleged furtherance of fringe religious beliefs followed by him and convicted, quote, Doomsday mom, Lori Vallow. In her trial, Vallow remained loyal, never allowing her defense to point the finger at her husband, the prophet. However, Daybell's defense is taking a starkly different approach from the jump. In their opening statements, Daybell's defense claimed that there is no evidence connecting the man to the murder of Vallow's two children, Tylee Ryan and J.J. Vallow, and placed the blame for the deaths on Vallow and her brother. Driving home the cruelty in which the children were killed, the state opened its case with testimony describing the discovery of the charred remains of Tylee and JJ's bound corpses on Daybell's property. Photos of the children's bodies shown to the jury caused a visible reaction from Daybell, who faces the potential of the death penalty if convicted of the murders. Court is dismissed the day we are recording this, but will resume by the time you're listening, and we will keep you updated as the trial progresses. All right. Do you think, and this may be a softball of a question, but do you think that this dramatically different approach? I mean, we saw Valo's case. I know you followed that closely. It seemed like her attorneys were fighting with one arm tied behind their back because their client, that we now know, was preventing them from making many of the strongest arguments they could have made. Not so much the case here. Do you think this dramatically different approach could possibly alter the outcome of this case? Is it that big of a difference?
Short answer, no.
Yeah.
But look, it depends. Like I was a little glib with that, but I mean, I thought John Pryor, who was defense counsel, was relatively effective in the second half of the day yesterday with respect to his cross-examination of Detective Hermosillo, who was the only witness that's testified thus far. Like, he was able to establish pretty effectively that things that we know that happened, where we know that Chad has not been charged with homicide or a crime of any kind. So, I mean, in that sense, it could be effective on a jury. And Joshua, you know as well as I do, I mean, it always depends. Are we getting that truly unformed clay juror, or are we getting jurors in Idaho that know all about this case, that were, the judge was able to rehabilitate them by saying, okay, well, you may have reached a conclusion as to innocence or guilt prior to trial, but are you able to follow the law and evaluate the evidence and then reach your own conclusion based on those two things? And if that juror says yes, a judge considers them to be rehabilitated. Now, as a defense attorney, I've always thought that that was utter ridiculousness.
Yeah.
I mean, once something's seared into somebody's subconscious mind, it's there and it's not going anywhere. I don't know if you've ever tried to change anybody's mind on an opinion online. Well, I'm pretty effective in terms of trying to, compel people to come to my way of thinking. And I have never changed anybody's mind online in terms of an argument or a debate. It's just one of those, it's human nature, So if we have 12 jurors that have never heard of this case, then I suppose there's a possibility that there could be a different outcome if Pryor is able to effectively show, look, Lori was the Svengali here. Like I was just the doofus. Like, she had me wrapped around her finger. Like, anything that she said went. I was so smitten with her. Her sexual wiles had me overcome. I wasn't able to, like, I was just not myself. Like she had this power over me that I cannot explain, other than the fact that what she said went. She was running the game. Once she got her hooks on me, once she found me, and she had been looking for a guy like me for a long time, and once she got her hooks on me, that was it. She was off and running, and I was just like a passenger on the train. I had no say so in what was going on. What Lori said is what went on, and frankly, her henchman was her brother, who frankly I think was actually in love with her. I think that he wanted to have a sexual relationship with his sister. I think that was it was a very weird relationship. That's where they're going to go with this thing. They're going to say that Cox was the henchman, that he was the trigger man, that he was the one doing all the dirty work. And Chad's going to sit there and say, I was the puppet. Literally, I still have the strings attached to my arms, from when she was manipulating me. And, I mean, that's going to be the defense. Whether or not a jury's going to buy it, it's hard to know. I think ultimately, when you have the death of two beautiful young kids, innocents, juries want people to pay. And, typically they're going to look at that person sitting at the defendant's table, and more often than not, it's going to be that person that's going to pay, just because that's how juries come into these things. If people are arrested, well, you did something wrong because
Yeah.
they got you here, and that's part of our work as defense attorneys, is trying to get them off that position and trying to get them to kind of focus on the facts. It's going to be an interesting trial. Like I was fascinated by Lori's trial. And as you said, Joshua, that defense was no defense. They did nothing. They verily even cross-examined the witnesses in that case. It was incredible. But as you aptly noted, Lori hamstrung them. She would not let them do anything that was going to throw Chad under the bus, or they don't have an insanity defense available to defense attorneys in Idaho. But what they do have is they've carved out an exception wherein you can attack the intent portion of a statute by saying that this mental defect did not allow them to form the requisite intent. And like in this situation, if I'm her lawyer, I would have been going to her and saying, okay, Lori, well, you're saying the kids were no longer your kids, that they were just vessels, that the bodies were just vessels, and then housed in those vessels were these dark spirits or demons. So in your mind, in actuality, that you weren't killing your children, which is part of the statute, the killing of a human being. Like, we have to send you to a forensic psychologist and psychiatrist to determine whether or not you were actually thinking that. If your mind was not allowing you to think that those were no longer your human children, but were in fact demons just being housed in a human vessel that's nothing more than flesh and bones, but that the soul and everything else was no longer your kids, in order to try to win this case, because it's the only thing that's going to work. Now, that of course would not have worked either, because as soon as the evidence came out that her and Chad were flitting about in Hawaii while the kids are missing for weeks, without her having a care in the world, with her hair, floating in the breeze in Hawaii, and, this big grin on her face. And in the meanwhile, they discover that her two beautiful kids are buried and burned in this pit in the back of Chad's, property. She was going down. Like, it wouldn't have mattered. But, they're not taking that approach with Chad either. I mean, so they're going to take the opposite approach. I mean, you could hear the beep, beep, beep of the bus, coming back in reverse to run over Lori and Chad, because they definitely are throwing them under the bus. I ultimately think that the jury's not going to buy it. It's hard unless you have a juror that has, actual experience of being in a relationship where they have been absolutely manipulated to the extent where they kind of lost control of their own faculties and their own ability to make decisions. And, they were just so beholden by that other person. Maybe they make a connection with one juror, but in terms of getting 12 of them to like buy it that this guy wasn't complicit, I don't see it happening.
Yeah. Yeah. Interesting, as you were speaking too, I wonder if they don't even have to go for broke and say that she controlled me so much that I couldn't help myself and I had to do what she asked me to do, as horrible and horrific as it was. But they could even say that, listen, we held these religious views, and they are extreme and fringe to many of you folks on the jury. But she took it to a level way beyond what Chad ever intended. And she took the lives of these children, and he found out about it after the fact. And that's where her control over him and his panic set in, and he helped her cover the whole thing up. That might be a more understandable story. Again, I agree with you. I don't think the jury will buy it, but at least it seems to have more legs to it. But how do they get that on without him testifying? So that could be an interesting.
That's the challenge.
Twist in this whole thing is they may have a great argument, and it's going to require him to take the stand. But when you're looking at the death penalty, maybe this is one of those times where you figure, I'm going to go for broke on this and see if I can't pull out a miracle. But
I mean, you have to in a death penalty case, right? I mean, you're not going to, like, at that point, you're not going to, like, you are going for broke. I mean, your alternate, the alternate ending to this thing is, look, you're going to be the first guy that's going to be put in front of that firing squad that we just reinstated here in Idaho, and you're going down because it's exactly like you said, but like even your approach still plays into that she was the puppet master, you know,
Right.
but and I think that he would claim ignorance as to the fact that the kids were being killed or that anybody was
Right.
being killed, you know, and that he did find out after the fact. So it's the same theory in terms of he didn't have knowledge of the homicides and, you know, the horrible acts that were happening as they were happening, finds out after the fact. And she's like, look, like, just relax. Like, this is how we're going to handle it.
This
You
is
know, just
God's
doing
will.
what she did.
Yeah.
Right. All that stuff.
Horrible stuff. Interesting case. It's just, you know, again, the incredible loss of life. But that is our show. Bob, thank you so much for coming on this week. Where can people find out more about you in the podcast?
So a couple places, obviously the podcast Defense Diaries, and we have a couple of them. We have the docket, which where we are handling with my brilliant, beautiful wife, Allison, who is also a criminal defense attorney. She is my co-host on that. That is where we cover current cases. We're currently knee deep in the Delphi case. And that is available anywhere you get your podcast, Apple, Spotify, all the podcatchers out there. And then we also have a pretty popular YouTube channel called Defense Diaries Podcast, which I'm going to have this handsome gentleman on in the next couple of weeks. So check that out. And that is obviously available on YouTube. And it's the same thing. We go live a lot. We cover some trials. So those are the spots you can find us.
Absolutely. And I encourage everybody to check it out. It's well worth your time. Really great analysis, like you've heard much today. So thank you again. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. You can find our Sidebar episodes wherever you get your podcasts, and we want to hear from you. If you've got questions or comments you'd like us to address, tweet us your questions with the hashtag TCD Sidebar. And thank you for joining us. True Crime Daily Sidebar.